Hello and welcome to what I would consider to be probably the most important video that we have on our Facebook account in terms of the information and how crucial the information is for purchasers of residential property, and that is the issue of buying residential properties and making sure a purchaser has done required searches and due diligence on the building certification matters for the property in relation to when it was built at the start, or first built, or any extensions that have been carried out. The reason I say that it is of such extreme importance is that for the last 20 years of doing this line of work, it's become apparent to me that quite amazingly about 50% of the jobs we do for our clients, when they test the marketing information they were given about the property on Domain and realestate.com with actual fact and doing a council search with the relevant authority to determine, well, what is on the council records about this property. On 50% of those occasions, they are told that what has been marketed to them on the internet is completely wrong, false, misleading, and not representative of the reality. So that's why, to me, it's such an extremely important issue, because people are buying properties that are not what they are, and it's a massive problem for the industry. It's all about issues surrounding the characteristics of a property and building certification matters. So what I mean by that is there's legal requirements for brand new construction of residential properties to have applications made, inspections carried out during construction, and the process is completed at the end with a final inspection certificate being issued, which closes everything down. This is all defined under the Building Act and the associated regulations, Building Act 1975 and Queensland state law. What actually happens for a lot of properties that we inspect, either brand new or existing properties that have had major work done that require formal approvals and certification, is that this process either was never ever activated at the start, it's all illegal building work, or it was activated with the issuing of an approval to construct, but it has not gone through the process it is legally required to do within the 2 years of the approval being given, and had all the inspections and approvals given, and then the final inspection certificate and closed. So that creates a massive problem. For example, if someone is looking at buying a house on the internet that's marketed as 5-bed, 3-bath, but originally it was 3-bedroom, 1-bath in the 1980s, let's say, and in the last 2 years it's had significant extensions done, house raising, and it's now 5-bed, 3-bath. On the internet it's marketed in that manner and sold to people in that manner, but unless it's formally done to comply with the legal obligations under the Queensland statute law, on council records it will still be a 3-bedroom, 1-bath, and the poor purchasers acting in good faith on the information on the internet believe they're buying a 5-bedroom, a 3-bathroom home. It's completely illegal under the Property Occupations Act 2014, but I've raised this with many government departments and no one seems to want to pick up about it, despite the fact it's a massive issue and can be significantly damaging financially, incurring major costs for purchasers, emotional tolls, and the stress of it all is just shouldn't be allowed in our society. But that's what's happening out there today, so this is why it's a very important issue. What does this mean for purchasers? Well, basically when they enter into a contract, the information they get is predominantly from the internet, from the marketing agent. That information is almost invariably never ever reflective or tested with a council search by the agent before they put the marketing online, and as our findings have shown, it's found to be 50% incorrect most of on occasion, 50% when our clients check and do searches. So purchasers buying what they believe to be 4-bed, 2-bathroom home, in reality, if they don't do a search and a check with the council authority, proceed with the sale, will possibly find out at some stage in the future, if they go to sell and people do a search, that what they purchased some years ago, which was marketed as a 4-bed, 2-bath, is actually on council records as a block of land or no building approval, and is a massive, massive issue for them, and they incur all of this worry, stress, and financial angst. In essence, basically, any incomplete building work or work that requires approvals under Queensland statute law that hasn't been done will be classified as incomplete, informal, illegal, and comes with the tag of the owners of that particular property where that's in place will have the probability of sustaining losses contracts not being able to be sold and they won't be able to sell the house. They may never ever be able to get the final inspection certificate because it's a very detailed process that requires a lot of things to be done to get that done. And in the event of, say, a fire, most insurance companies will say, sorry, we're not insuring you because you've got unapproved building work, it's not complete, it's not compliant with Queensland state law, goodbye. Big problems. Quite astoundingly, the provision within the contract for the purchase and sale of a property, which has been designed by the REIQ, which is the Real Estate Institute of Queensland, for governing body for the real estate agents, is designed in a manner which is very basic, vague, minimalistic, and gives no rights really to the purchaser of a property, barring a few little ones, but that's tagged with manipulation as well. It gives nothing at all in the contract for the ability of a purchaser to do a search and make sure that what they have been marketed actually reflects what they're purchasing, and if they do that search, then they have the ability to pull out of the contract because they've been misled. Nothing in the contract about that. Unless that's organised by a prudent and diligent purchaser, they'll have no safety. They'll have to buy a property that's been completely mismarketed to them and suffer the consequences because the contract doesn't allow them to pull out. To compound this further, many conveyancing solicitors that act for purchasers also don't stress the need and importance for their clients to don't act on the information on the internet, because most of the time it can be wrong, or a lot of the time it can be wrong, and the importance of doing a council search to validate the product they're buying, because only searches with the councils can determine exactly and concisely what the characteristics of a property are. They are the record keepers. Conveyancing solicitors generally won't stress that importance. Very few of them do, based on what I hear from my clients. They also do they not tell their purchasers of the need to do that, they will not carry out the search which is there for them to do to actually validate the product and check with the councils, hey, what is on the records for my client here with this property? Now, I would have thought that a conveyancing solicitor, that would be the first thing they should do for their client if they're looking after them in the right manner, but most don't do it. It's astounding. I always say to my clients when I do jobs, and it might sound a bit funny to them, but when they turn up on site, I say, look, I'm doing a building and pest inspection for you, which is going to give you a lot of information about defects, building issues, timber pest matters, but there's a more important thing that you need to do with this potential property purchase, because I know that most of them don't know about this issue that I'm talking about now, and that is you need to immediately get on the phone and start checking with your local council about what they have on records for this property. And I always get the response, they don't really know what I'm talking about. And then I explain to them that you're under contract legally, you've acted on the information from the real estate agent, domainrealestate.com. Has anyone validated to you and given you the records of the council to show you that what you're buying and has been marketed to you is actually that? And when they start understanding this, and I explain that I see 50% of my clients be misled, they then go forward and check and do the council searches. It's so much more important than the information within a building and pest, because what are you buying if you don't have a property that's actually got building certification? You won't be buying what you think you're buying, but you'll be buying a big problem. You'll really big risks of financial loss, massive emotional top, potentially crippling for you, devastating as well. So always try to validate the product before you enter into a contract to buy a property, and tell everybody that you know about this because of the endemic and problematic nature of what I'm saying. You cannot rely on the information on the internet, because it's just so far away from the truth on a lot of occasions. The general legal requirements for building approvals and certification for residential construction really came into effect around about 1975, and that was when the Building Act and associated regulations were enacted. Before that, there were some council ordinances that building approvals could be done, but it wasn't common and legally required for every building approval under statute law. That came in 1975, and it's been in place ever since. There are some kinds of things that don't require building approvals. An example would, because they're minor, an example would be a fence under 2 metres high. There's no need to get stuck in bureaucracy and lodge in building approvals and applications to build a fence under 2 metres high, because it's simple building work. But the majority of significant construction work, and it's all defined in the Building Regulations Schedule 1, what is permissible and not permissible, will generally require a building approval, especially new construction work of residential properties, and existing properties that undergo extensions and renovations of significance will also require building approvals, applications, certification and inspections. Compulsory under Queensland law. So that came in 1975. The building certifier is responsible for oversight. The builder obviously does the work, but there's a building certifier who is now independent, and it used to be part of the council, but they're now privatised, and they oversee the issuing of this and the basically the signing off of these kinds of things, certification matters for residential construction. They have to give copies to the local council authority, however, and that's how the council keep the records, and that's why searches are done with the council when properties are bought and sold, because they hold the records. Building certification issues and relevance to a building inspection. As I said a little bit earlier, despite the gravity and importance of this matter, it's actually excluded from the Australian standard for residential building inspections. Completely excluded. The Australian standard is more interested in talking about minor defects and trivial matters rather than something of this magnitude, which I completely disagree with, based on the effect it can have and the importance of this issue compared to what the Australian standard documents in a lot of areas. When you know about how extremely problematic and costly and traumatic it could be to a purchaser, and I've seen it often, and that's why I'm committed to try and do something about it. The fact that it's not in the Australian standard is criminal, really. It's extremely problematic also for purchasers who are unaware of this issue, who engage inspection companies that only adhere to the minimum requirements of the Australian standard to do their work. The Australian standard is very basic for building inspections, and it has many exclusions. One is the specific identification of any building certification matters, building approvals, additions and extensions, and what's involved with that. So most inspection companies, because the reality is most inspection companies that I know of in Brisbane and have seen in the last 20 years, will only adhere to the Australian standards and not give information over and above that. Therefore, they don't comment in this area. So it's really problematic for a purchaser who engages a company of that nature, because they will not get any information about this issue. The first issue that would arise in that scenario would be that obviously no information, they can't make an informed decision. The building inspection company, by not telling them about this or talking about it, places a purchaser in a scenario where they proceed with the sale and they buy a property that is not reflective of what they thought it was, when really any competent building inspector and inspection company should be aware of this matter and should be more than happy to put comments in their report and advise people about it because of its importance, notwithstanding that they may need to disclaim any comments they make for legal reasons, because it is excluded from the Australian standard. We certainly talk about it, and I actively tell people about it and the importance, and as I say again, it's, in my opinion, far more important than having a building and pests inspection done and acting on that information, because if you don't start at square one with saying, is my property actually a property, and finally inspected, I wouldn't bother doing a building and pest if it wasn't, because it's just too, walk away, it's just too problematic. That's how I would explain it. So the second issue with engaging a company that doesn't comment on building certification issues for a purchaser is that because the inspection company don't mention it in their report, there's no legal standing for a purchaser if they find out about lack of certification for whatever reason during the purchase and sale of the property, and it's within their building and pest clause timeframe, to legally pull out and not be challenged by the vendor. There's no provision in the contract. The contract that's used for the purchase and sale, again designed by the RIQ, states only that a purchaser can get a building and pest inspection report, can act on the information in that report, anything excluded you won't have in there, and can only pull out if they're not satisfied and acting reasonably with that information. So clearly, a company that doesn't talk about these issues, building certification, is going to leave a purchaser high and dry on many occasions, and with no legal basis to pull out. So they're not getting fairly informed and making the right decision, and they're legally exposed as well because of the horrible way the contract is written that is used for the purchase and sale of properties. Now, the extent of the problem and the type of properties affected. 50%, as I've said, of our properties, based on our experiences, it's horrifically common, and the only way that you can determine exactly what you're buying as a purchaser is by doing that formal search with the council. And I would strongly recommend that before anybody puts in an offer or contract to buy a purchase of residential property because of the nature of this issue, that they do some time spending researching and searching with the local council authority about a property they're interested in, and have them confirm to them in writing that yes, this is a 4-bedroom 2-bathroom property that's accurate with what it's been marketed as, or no, it's not, there's problems here, there's no final inspection certificate. Because if the purchaser does that before they enter into any contract, they're not legally bound, and they can avoid that property and move on. That's the best way to handle this, because if you try and do it retrospectively, there's no provisions in the contract, you're at the mercy of a building inspection company commenting on it or not, and as a purchaser you're extremely vulnerable. So that's why people should know about it, deal with it before you go to contract, and you can do that by doing searches with the council. The issue doesn't just affect new building work, it affects existing structures that have had significant extensions and alterations that require approvals and certification under the Building Act. Basically, the ramifications of purchasing properties, I've touched on a little bit with significant financial loss, emotional stress, but let's just go through that again. One of the other ones I haven't mentioned is that for any property that has got unapproved building work, or building work that was carried out that hasn't had the required certification and approvals under the statute law of Queensland, the majority of the insurance companies providing replacement fire and theft in the marketplace will have secret little clauses in their exclusions of their policies for people who are unsuspecting and not aware of it, that they will reject any insurance claim for fire, rebuild, or anything of that nature, or any claim of significance for properties that have got unapproved or illegal building work or uncertified building work present. Massive amount of properties have this, and if you're paying insurance to an insurance company for rebuilding fire, or to get a claim, and you have got unapproved building work present, you're wasting your money, in my opinion. And I'd be doing some serious research about with your insurance company, just checking their position on it. There are some companies that will insure properties that have unapproved building work, but it needs to be clearly stated in writing. The majority of the bigger companies won't tell you about this, they'll take your premium, but if you make a claim in the event of a horrible scenario of a fire, then you'll be advised of it. If you just check your product disclosure statement, I think it is, and go to the exclusions of your insurance provider, it will all be listed there, and you should see a statement there which says that any unapproved building work at a property will result in the rejection of a potential insurance claim. Another factor that you should be aware of as a purchaser is there's a common practice by agents when they're caught out with their marketing being completely incorrect and false and misleading and untruthful. When diligent purchasers do a search with the council and they go back to the agent and say, hey, this isn't a 4-bedroom 2-bath, it's 3-bedroom 1-bath. As quick as a flash, the agents will turn around and go, don't worry about it, it's not a big issue, you can move in and you can deal with it and get certification when you move in. It's a piece of cake. Rubbish. Completely untruthful. The process will start with, first of all, anybody that buys a property that hasn't got building certification for all of the work that's been done retrospectively or originally is at serious risk of never ever getting that certification, because there's no guarantee. There's a long and lengthy process you have to go through to try and get it. And that will involve initially, so first, there's no guarantee of getting it, but the initial thing will be, give me $2,000 to reinitiate or restart the building approval, if there was one done. If there wasn't, it's more problematic. You'll have to get planned soil tests, and thousands of dollars will be needed before you even start to get to base one. So don't ever believe what agents will say. Common response is that, no, don't worry, it's a piece of cake, move in and you'll get it done. It's just a tactic to try and get you to proceed or based on emotion, but not on fact and reality. I would strongly suggest that any purchaser that goes through and is getting to a sale and are advised of unapproved, uncertified building work, never ever take it on, never ever proceed with a sale on that basis, and make it conditional upon the vendor providing you with that certification and legally binding in the contract. At the end of the day, they marketed the property to you in a false manner, and which was representative of what you acted on. And if that's not what it is, the vendor should have the responsibility to get that done for you, because legally that's the best way to do it. It's the safest. Now, most vendors will not do that. They'll just let the contract crash because they are completely aware of how difficult it is, and they'll want some other mug to come along and take on that liability. Don't be that mug because of what's involved. The other one is, of course, if you take this on as a purchaser, you've inherited a problem when you come to sell. your baby. So when you come to sell this property down the line, if you don't go ahead and try and get final inspection certificate, and you're not successful, if you do try and get it and you can't get it, then you've got to try and sell the place. And there's going to be other people that are queuing up wanting to walk away if they find out, do searches, that your property is not formally inspected. It's becoming more and more common and recognised by purchasers, whereas years ago it wasn't as relevant as it is today. There's more recognition, but not enough. My own personal belief is that houses shouldn't be sold and marketed by real estate agents or vendors unless they have legally been made to do a search with the council authority by law, and they reflect the results of the council search with their marketing. That's not the case at the moment. They just market what they want with no consideration to the reality of what the formal records are. So, suggestions to deal with this and how to avoid this so you can be in the best possible position to avoid risks of financial loss and buying properties that are not what you think they are and inheriting massive problems. Be aware of the issue. Always engage companies, inspection companies that are going to comment about the issue and put it in their report, so you have an ability to act on that information and potentially withdraw from the contract if you find out there's unapproved building work or those kinds of things. In the event you have uncertified building work which has been identified by the building inspection company within the report, they're a diligent one and they exceed the standards, it gives you that provision to pull out of the contract, as I just said. But again, don't ever continue with the purchase of the property, in our opinion, on the basis that you will get the certification later on. Make it conditional on the vendor to do that, and that's the safest way to protect yourself. So that would be our very strong recommendation, that you do that course of action. The best methods of dealing with this issue would be, prior to going on to contract, because you know about this issue, you've educated yourself about it, amend the contract when you fill it in to have a clause in there that says you will be doing a search. Well, first of all, you can do a search before you go to contract with the council and walk away and not even get to the contract stage, because you've done your search and you know what the reality is about the property you're looking at buying. Secondly, if you haven't had time to do that, you can put an amendment in the contract to put an addition in there that says you have the right to carry out a search with the local council authority about the property you're looking at buying, and if there are any anomalies or problems with the certification and it's not reflective of what is being marketed, then you can withdraw from the contract free from penalty, and that's the only way legally you'll be safeguarded, because that's not in the contract at the moment. So yeah, those are the two best ways. Be proactive, do the searches before, and avoid getting into a scenario where you're legally contracted to buy a property without taking the necessary provisions, like putting in standard clause or adding a clause in to say that you can do searches and things like that. So yes, you probably can tell with the way I've delivered this and the emotion and some of the things I've said that it is a really important issue. Nowhere near enough people know about this that should, and I deal with people buying properties daily that don't know about it. So I'm determined to get this message out, and please tell everybody that you know who is buying residential properties in the near future, or you know of that maybe, to also watch this video and absorb this information and take control of the situation. Don't let what's currently in place, which is manipulation by vendors and marketing agents with getting you to sign contracts that give you no legal rights about this matter, building certification. Don't fall into that trap. Take control and make sure you have all of the legal steps taken and provisions and clauses in the contract to protect you and not let you be misled and lied to with advertising and buy something that's not right. So yeah, hope you found this informative. And yeah, if you're buying in the future, we'd love to help you out with any potential property inspections, and thank you for watching.